Well, for companies that do not actually have an operation entity in China, but they have an OEM manufacturer in China, we would still strongly recommend to register a trademark. If you have a manufacturer, that means your brand and your trademark and your products have been exposed to quite a large amount of public. Although the manufacturer are binding to the confidentiality agreement or your contract, but there is still a risk that this person or the other entity can take advantage of your trademark. And we actually have been seeing cases like this, and later on it gets very bad with litigation, arbitration. So filing will be at a very defensive aspect of protecting your trademark, even though you're now selling in China. So that's from the manufacturer side. And from the other side, which is about exporting your goods manufactured in China and exporting to your destination country. And the custom registration actually require to record your trademark to make sure they are genuine products. So if the trademark registration does not come from you, come from another entity, and the registration took advantage of that, it actually can stop your actual export, which will create quite an amount of damage to your factory and to your whole business. So filing is very, very important in China. And a very important side note is China is the first to file country, which means timing is very important. If you wish to file and using an agent, first we'll probably ask you to sign a power of attorney authorizing us to submit the application. And then we'll provide you with a list of the documentation that we'll need from you. And also, if you have filed your application in Canada, we may also need the files from the Canadian Trademark Office as well. Well, generally, the Trademark Office will need the full name of the applicant and the nationality and the address of it. We also need a photocopy of the certificate of the good standing of the applicant, as well as we'll need all the trademarks that you wish to register and their specimen. With specimen, we also have some requirements, how high resolution it needs to be, how big it needs to be, so it needs to follow certain guidelines. And after that, we'll be looking at the goods, which class that you're interested in registered in, and which subclass you'll be interested in registering. You can have a 6 months time window to file that same application in China. At the same time, you will be enjoying the benefits of your first filing date. And after you have filed the application, you will have another 3 months time window to provide us with all the documentation you've given to the Canadian authority. And it will be asking you to give the Canadian authorities contact, because we'll need the official papers to prove that these are genuine copies. So there are a few ways that you can still enjoy the benefits of your first application, but at the same time, there are people to help you to file your first application in China as well. Well, regarding the class and subclass classification in China for trademark practices, totally China has 45 classes, and from 1 to 34, these classes cover goods, and the rest of them cover services. So when you file a trademark application, you would need to choose which class that you wish to apply for. And also under that, very importantly, is you have to choose subclasses. And this is the unique part of the trademark practice in China, is even under the same class, each of the subclass stand on its own. For example, if you in class 15, you have different subclasses and they won't be seen as conflict. But at the same time, increasingly, we have been observing cases that the authority has been for somehow adjusting that principle. For example, under class 25, which covers apparels and accessories and what you may be seeing in a boutique shop. Increasingly, we're seeing cases that a ring and a belt can be seen as conflict, although they do actually fall into different subclasses. So in that aspect, I think it's also thinking about China's trademark practice is actually evolving, and you will need someone to help you to file the way that suits your interests the best, and also not creating any more fees or more time for you later when you have more goods and services. If you wanted to apply a multi-class application saying that you want to apply several classes in a package at the whole thing, now it is acceptable. After the amended new trademark law took effective in China in May 2014, now the authority do take a package application, if I may say so. But we do not actually recommend such practice, even though it looks like it saves a lot of paperwork, it saves a lot of time, you can just chunk one in at the same time. We think it actually creates more hurdle to jump through in your later on, say, reviewing period where you're reinforcing your rights period. For example, if you have a multiple class application, like if you have 4 classes and after you're submitting and they've done the review part, they think maybe 2 classes are not suitable for application, you would have taken all your application back and ask either your agent or yourself, you have to divide them into all the different groups, which actually increase more time to categorize all the different paperwork. And also you would need to file again and asking for review. So in that aspect, you are not actually saving a lot of time, you're actually spending more time and money instead of just having one single class application for 5 different classes. And also for fee considering, submitting a multi-class application doesn't actually save you any official fee at all because the office is charged per class. So in that sense, we don't think it's actually beneficial to any of the party involved to submit the package. And also we have actually been in extensive discussion with the trademark office official. They didn't really enjoy to receive such a large amount application in one time because they will have more time to enter the data, they will have more time to review the same file, and they will have to divide again. And during that time, human error can occur, and we all know we don't want to bear the cost for that. In terms of talking about your house trademark, which could be in English and it could be also in French, it could also be graphic. And when we're talking about you're entering China in any sense, where you're having an operation entity in China, say you're a manufacturer also, we get asked a lot whether they need to file a Chinese, either a phonetic equivalent of the Chinese trademark or the meaningful, the literal translation of Chinese trademark. We actually have seen a lot of cases that's very interesting is we're given the full advice of strongly recommending to register Chinese trademark, but a lot of clients were very hesitant about that. But we would definitely think it is very, very important to register a Chinese trademark. And to an extent, you may register quite a few of Chinese trademark as your defensive strategy to protecting your brand from diluting. When we're mentioning about brand dilution, it's largely derived from a marketing perspective, because once your products and brand becoming more known in China, and Chinese people who mostly still speak Mandarin Chinese as their language, they will need to find a way to circulate your brand message. So they do not necessarily perceive your brand as your original design or your original language. They will come with sometimes a phonetic equivalent of the Chinese mark, or sometimes abbreviation that delivers some of your brand message. So your brand, most of the time, it will not be seen as your original letters. So in that sense, if your trademark in Chinese is not registered, and you can have people take that advantage and register the Chinese trademark. And later on, you will have a very, very tough time in opposing that trademark because you will need to provide a large amount of evidence proving that your original trademark has a very strong association with the Chinese trademark that someone else has filed for. And this chance is very low. We've done an inner research, and the chances of successfully opposing a mark could be lower than 5%. Well, procedure-wise, you will go through 5 steps. The first is that you have to submit your application, the application form, along with the list of documents required by the office. And the office, after receive the full documentation, they will issue you a receipt in 2 or 3 days, telling you that your application has already been considered. And after that, you will go through 2 stages of examination. The first one is a formative examination. It examines the formality of your actual application and all your paperwork. And the next one goes to substantive examination. And later on, after the 2 stages, it will be published. and there is about 2 to 3 publishing period that asking for public opinion. And during that time, you may receive opposition notice, because any third party in China can actually file an opposition saying like the applicant is not entitled for this trademark. But if we have answered that successfully and the registration will be completed in about another 2 or 3 months, total time we'll be looking at a year or year and a half, or sometimes 2 years if you receive a lot of oppositions and you have to answer for them. But generally we would say about 1 year or 2.